Repossession is a term used to denote a financial institution taking back an object that was either used as collateral or rented or leased. Repossession is a self-help type of action in which the party having right of ownership of the property in question takes the property back from the party having right of possession without invoking court proceedings. The property may then be sold by either the financial institution or third-party sellers. The extent to which repossession is authorized, and how it may be executed, greatly varies in different jurisdictions. When a lender cannot find the collateral, cannot peacefully obtain it through self-help repossession, or the jurisdiction does not allow self-help repossession, the alternative legal remedy to order the borrower to return the goods is replevin. The security interest over the collateral is often known as a lien. The lender-creditor is known as the lien holder. Repossession in various jurisdictions. Generally, the existence and handling of repossessions varies greatly between jurisdictions. In some jurisdictions, self-help is limited to special circumstances, so in general, the right of possession can only be enforced by a court or other official agents. United States, when a provision of law requires when repossession takes place, the lien holder has a non-delegatable obligation not to cause a breach of the peace in performing the repossession, or the repossession will be reversed, and the party ordering the repossession will be liable for damages. This requirement not to breach the peace includes even if the breach is caused by the debtor objecting to the repossession or resists the repossession. In M. Bank El Paso v. Sanchez, 836 SW2D 151, where a repossession agent towed away a car even after the loanee locked herself in it, the court decided that this was an unlawful breach of the peace and declared the repossession invalid. The debtor was also awarded $1,200,000 in damages from the bank involved. Procedure of a repossession in the United States. Repossessions are carried out pursuant to state laws that permit a creditor with a security interest in goods to take possession of those goods if the debtor defaults under the contract that created the security interest. In particular, all 50 U.S. states and the District of Columbia have enacted Article 9 of the Uniform Commercial Code, which generally permits security interest holders to repossess goods if a debtor is in default, and the repossession can be conducted without a breach of the peace. Being in default means that the debtor has failed to fulfill his or her obligations under the contract. Many U.S. states have enacted additional laws that apply specifically to the repossession of purchased and leased automobiles, and which are intended to afford additional consumer protections. Typical requirements include mandating that auto lenders provide consumers with opportunities to either reinstate or redeem their purchase or lease contracts after their vehicles have been repossessed. Reinstatement entails a consumer paying all of his or her past due amounts plus the creditor's repossession expenses, and then reacquiring the automobile as if the repossession had not occurred. Redemption entails the consumer paying off the entire contract balance and then being given ownership of the vehicle free and clear of any contract obligations. Many consumers mistakenly believe that they are legally entitled to a grace period that prevents creditors from repossessing goods until the payments are a certain number of days overdue. In reality, however, grace periods are non-compulsory business practices that have been adopted by most consumer lenders. There is nothing legally preventing a creditor with a security interest from repossessing the goods if a payment is late. The only exception to this rule is if the creditor does or says something to lead the debtor to believe that the goods will not be repossessed, notwithstanding a late payment. If a creditor tells a debtor that a payment may be made a particular number of days late, and then repossesses the goods before that date, the creditor is guilty of conversion. That being said, unless the consumer received permission to make a late payment in writing, it may be difficult for him or her to later prove that the creditor agreed to permit the late payment. Because of the difficulty proving oral statements, Some unscrupulous creditors try to lull debtors into false senses of security with a tactic sometimes called the gab and grab. The creditor will orally agree to give the debtor extra time to make a payment. This is the gab. But the creditor is only doing this to facilitate the repossession, the grab. The creditor ignores the oral agreement to extend the time of payment and arranges for an immediate repossession. This tactic has been deemed unlawful by numerous courts. If a lender finds itself in the situation of needing to repossess property while the borrower attempts to avoid this, the dealer may contract the work of repossession out to a repossession agent. Many things can be repossessed, but most repossession agencies focus on auto-repossession. The repo agent normally uses a tow truck or pickup truck with a special towing attachment called a boom, but sometimes they pick the lock or obtain the key from the car owner. Usually, the vehicle owner must be notified of a repossession. The repossession agent will find the car and check its information such as the serial number to make sure they have the right vehicle. If there is a match, they will attempt to hook up the car to the tow truck and tow it away, or pick the lock and drive it away. Repossession does not necessarily satisfy the loan. If the repossessor sells the asset for an appropriate amount, and if that amount is less than the amount of the loan, and if the repossessor sues the debtor for the balance in a timely manner, the debtor may be liable to pay the balance. Whether a debtor is actually liable for a balance depends on jurisdiction and on the details of the loan contract. In the case of a non-recourse debt, for example, the debtor is not personally liable for a deficiency. United Kingdom, England and Wales. These numbers and text relate to home mortgage repossessions in England. Number of repossessions in England. Source: Council of Mortgage Lenders and the Ministry of Justice. In 2010, there looks to be a downtrend though, as lenders seized 9,400 properties in April, May and June, 400 fewer than in the first quarter of 2010, according to the Council of Mortgage Lenders. Germany. Repossession in the form of self-help is generally illegal, and an act of self-help repossession constitutes theft. In almost all cases, if the debtor is unable or unwilling to pay an outstanding debt, the creditor must first obtain either a court order authorizing the repossession or a regular court judgment. The debt must then be collected by an officer of the court. Only this officer of the court may use force to collect the debt. In particular, neither the creditor nor private debt collection agencies may use force or seize property against the will of the debtor. Some very specific forms of self-help repossession are legal. For example, a landlord may seize the tenant's property in the rented object if there are outstanding payments.